Caddo Parish District Attorney James Stewart is joining us for a little bit. Hey, Mr. James, welcome back to KEEL. How you doing today?
Good morning. All is good.
I want to talk to you about the amendment on the ballot requiring unanimous jury verdicts for felony convictions in Louisiana. You support this? This has kind of got a bipartisan group of folks for it. What's the big push, and why are you supporting it and want folks to vote for it?
Well, it's a correction in the law. Louisiana is only 2 of 50 states that actually have non-unanimous jury verdicts, and it's just the right thing to do.
Does it make it more difficult? Will this make it more difficult for prosecutors, district attorneys, to get guilty verdicts? I mean, before we had the split.
Well, in federal court, they've always had to do it, and I tell people if they can do it in Mississippi and Arkansas, I don't see any reason why we can do it. We can't do it. It's just an adjustment in the law, and I really don't see a big difference in what we'll do on a day-to-day basis.
Mr. James, a lot of the campaigning that is being done in favor of this change that the folks in favor are doing. In fact, I'll read it to you right here. It says, Louisiana does not meet the beyond a reasonable doubt standard. What does that mean?
I wouldn't necessarily agree with that. I just think there's no reason that we are not consistent with the other states. I do believe we meet the reasonable doubt. And in a lot of cases, it's really not a difference between 10 to 12 for innocent and 10 to 12 for difference. Normally it's 10 to 12 for responsive, 2 for responsive verdict. So like I said, I don't think it's a major change. It just makes us consistent with federal courts and consistent with all the other states except Oregon.
And Erin had said 4 felonies. This isn't all felonies. This is for, I think the word I saw was many serious felonies. What is included? What does this affect? What will this not touch?
Right now we have unanimous jury for capital cases and for 6-person juries, which are what we call cases where punishment may not be with hard labor. But a vast majority of felonies that we try, it would make all of those unanimous juries.
Talking to James Stewart, the DA in Caddo Parish. Let me ask you a question then. Will this change just a little bit the jury selection process? Now, every one of those folks has to be up there paying attention. You can't have one of them that's kind of out to lunch.
Yeah, I think we'll pay closer attention to what we're doing. But what it does mean is every person's vote counts. In the past, once they got to 10, they quit counting and they moved on. And they'll just have to listen and have a conversation. I've talked to people in Texas and other states, and they just tell me it's if you have a good case and you do a good job of selecting your jury, the judges will make the jurors go until they can reach a verdict. The opposite side of it is it takes 12 people to acquit somebody. So if they want to let somebody go, it takes a unanimous agreement. And if all 12 of them agree, then maybe that person ought to be acquitted.
One thing somebody mentioned to me, a lawyer mentioned to me, that now you really have to be careful of a rogue juror, somebody who gets on there who is just anti-prosecution, anti-police. Does that worry you at all a little bit? Somebody going rogue and just, changing how a case should come out?
The way we select jurors now is we select as if we need all 12. Okay, so we're always looking out for people with agendas and rogue jurors, and the other side looking for rogue jurors against them. So in the way we choose jurors, that will not change. It always concerns us, so we're always looking for them.
You had, to this point in our conversation, you've talked about sort of the legal aspects of it all. In your mind, or maybe more in your heart, based on your experience, is there a moral component to this?
Well, there is. I mean, when you start thinking about it and look at why they had non-unanimous juries, there's no reason to continue it. I'm not with the group that's bringing it. I was not behind it. But when I looked at it, I understood the argument that it's not necessary morally. It's the right thing to do to make us consistent with everybody else.
This rule, obviously, we know dates back to the early days of segregation, and this will get it out of our courts, right?
Correct. And part of the problem we have is the perception of a large group of people in Louisiana that the justice system is not unfair. So this just takes away some of their ammunition and to prove that it is fair and it treats everybody once. It makes convictions more certain. It takes away appeals. You know, we've already had a judge in Sabine Parish rule that non-unanimous juries are unconstitutional. So we've got to deal with that.
You know, Mr. James, Erin just touched on it, so I'll follow up. She mentioned segregation. In your mind, in the minds of many, is there a racial component to this?
I think there's a racial component when it was first created. I don't think there's a racial component of it now.
Yeah, I'm looking at a headline. Louisiana voters will have a chance to strike down a Jim Crow law this November. Do people see it like that still?
I think some people are going to do whatever they think to make people pay attention to it to vote. You know, one of the problems you have on a ballot is there are so many amendments, people miss it. So they're just trying to get people excited about it. I don't look at it that way. I think it's a correction in the law, something we need to do for a lot of reasons.